Hello everyone and welcome to this CET webinar with a focus on fitness to practice. Thank you all so much for taking time out of your evening to join us for this event. I'm Dionne. One of my roles is to oversee the fitness to practice function for the General Optical Council, and I'm joined today by our Head of Case Progression, Keith Watts, who leads our end-to-end case progression function, and also Roma Malik, an optometrist and one of our in-house clinical advisors. So today we're going to explore the reality behind some of the myths about fitness to practice. We know they're out there and we know that they worry and concern a lot of our registrants. By the end of the session, you should have a much better understanding of the fitness to practice function and why it's so critical to our overarching objective. You'll be aware of our acceptance criteria, which helps us to decide if we'll investigate a concern that's raised with us. And you'll also have a much clearer understanding of the decision-making points that run through our investigations. We've got a lot to fit into the next 50 minutes or so. Keith's going to be leading on the presentation for us. There's going to be a few quick quizzes throughout just to assess where your current understanding is. And once we've gone through the content, there is going to be an opportunity to walk through some case studies to see how your decision making stands up. Please do drop any questions that you have into your question box. And if we don't get to them by the end of the session, don't worry. We are producing some written content to support this event, and we'll aim to respond to any broader issues or questions within that, along with any case studies that we may not get to today. So just before I hand over to Keith, I want to kick us off with our very first question. Approximately how many optometrists, dispensing opticians, students and businesses are currently registered with the GOC? So we've got 44% of you think it's 45,000, 34% of you 31,000, 13% of you 57,000 and 9% of you 23,000. So well done to 34% of you. It's 31,000 registers currently registered with us. Do keep that in mind as you are now taken through the fitness to practice process. Keith, over to you. Thank you.
Thanks, Dionne. Good evening, everyone. I can't see you, so I hope you can see me or at least hear me okay. As Dionne said, a lot to get through in a relatively short space of time. Fitness to practice process can be quite convoluted. So I will be whizzing through quite quick. Brief overview, we'll be looking at the various stages of the fitness to practice process. We've got some case studies that we will hopefully have time to have a look at towards the end. And also, if we have time, we'll touch on the general direction of travel as it relates to professional regulation. So starting point for fitness to practice is the Opticians Act 1989, which I'm sure you're all familiar with. Council has an overarching objective, which is the protection of the public. And that breaks down into the four component parts that you can see on the slide. The one that's highlighted is the one that relates primarily to fitness to practice around promoting and maintaining public confidence in the profession, which is one of the objectives of the fitness to practice process. But what actually is fitness to practice? On the two slides, on the slide there's two quotes. There's firstly a quote from the Nursing and Midwifery Council, which I always think sums it up quite nicely. It's about managing risk and the potential risk that someone might pose to members of the public in the future. What it's not about is it's not about punishing people for past events. And I hope that will become clear as we walk through the slides this evening. Also, Professional Standards Authority, who oversee healthcare regulators, in 2014 published some guidance about when concerns should be referred to a regulator. And this is quite helpful as well, because they talk about where someone has been harmed or there is the potential for harm, and that's the public protection angle. They also talk about where, if the situation is such that if the regulator doesn't take action, that the general public could lose trust in the profession, and that's that public interest angle. So why does that matter to you? Well, as registered professionals, as with anyone in life, everyone makes mistakes, but registered professionals also carry their professional status with them at all times, and there's a famous quote to that effect in case law in a case called Bolton against the Law Society. The fitness to practice process is really about promoting learning and reflective practice, as I said previously, not about punishment. And for anyone involved in the professions, understanding how fitness to practice works can be of great assistance. You know, as said at the beginning, everyone makes mistakes. So if someone is unfortunate enough to go through the process themselves, or if they are supporting someone who is going through the practice, understanding how it works can be very valuable generally. So on what basis might someone go through the process? Well, I won't go through all of the sections that are set out on the slide. These come from the Opticians Act. The most common ones are probably the first four. Misconduct, which is a general heading, which covers a range of things, which includes clinical matters, and is generally defined by case law as referring to serious professional misconduct, which may be an expression you've heard on your travels generally. Deficient professional performance, as it suggests, and that is something that connotes a standard of professional performance which is unacceptably low, with reference to a fair standard of someone's work. Adverse physical or mental health, so adverse health can be an impairment to someone's fitness to practice safely. Likewise, conduct issues which result in convictions or cautions may also be a matter that impairs someone's fitness to practice. And the whole fitness to practice process is underpinned by a decision-making framework. So I've already touched upon the Opticians Act, which sets out those potential grounds of impairment. GOC, as you know, sets the standards for the profession, also sets out entry-level competencies that registrants must attain in order to enter the profession in the first instance. The structure is also supported by guidance issued by external bodies and a whole wealth of case law that is both recent and much older. And underpinning the fitness to practice process generally is a principle that's well established, that registrants are judged against the standard of a reasonably competent optometrist or dispensing optician. So into the process itself, and it all begins at triage stage. So complaints, new referrals come into the GOC via various different routes. Most of the referrals, as you might expect, come from patients, but we also get referrals from other sources, from the police occasionally, sometimes from NHS England, lots of different places. We have a triage process, so at this stage it's just a concern that's received. This is not the opening of a formal case. We have three key questions that we ask ourselves at the triage stage when we're carrying out an assessment. The first one is, do we have jurisdiction? So does this relate to someone who is on the GOC register? Secondly, do we have the complainant's consent to use their data and to share their concern more widely with the registrant, potentially with the Optical Consumer Complaint Service, potentially ultimately with the Professional Standards Agency. And thirdly, the real key question, which is, does the concern we've received amount to an allegation that someone's fitness to practice is impaired? And that's where we really have to wrestle with the process and the issues that have been raised, because that's not a straightforward question, and that may require us to undertake more work to understand what the complaint is about and the level of potential seriousness of the complaint. And over the last year or two, we've done quite a bit of work to reform our triage process. We used to have to pretty much put everything we received into the formal system, just because we had no legal threshold. we've managed to work around that over the last couple of years and develop a form of what we call acceptance criteria. And we have two different sets of guidance, one relating to individual registrants and one relating to business registrants. And this sets out some underpinning principles in terms of which matters ought to enter the formal investigation process. And at the same time, we've expanded the amount of work we do at triage stage. So we're getting more input into the complaints that we receive. So we're getting more clinical input from Roma, for example, who's here with us this evening. In some cases, we are seeking input from registrants at triage stage, and also occasionally from employers at that very early stage. And that is, all of those things can be very crucial in terms of our decision making, in terms of whether something needs to go any further. And this new process has involved us, or has enabled us to keep more cases out of the formal process, and you'll see this in the figures as we go through. And so one of our key messages this evening would be around engaging with the GOC if you're either involved in a complaint yourself, or if you are supporting someone else who is involved. Potentially engaging with us at that stage can help us to make a decision not to open an investigation. We always advise taking advice from your professional body, of course, but this has been very successful over the last year or so in reducing the number of fitness to practice cases that are in the system, and we'll see this as we go through. There is also, just finally on this slide, if someone is unhappy with a decision we make at triage stage, whether that's a decision to close a complaint or whether it's a decision to open an investigation, there is a right of review against that decision that we make. So just with all of that in mind, we're going to now move on to the second quick quiz question, which is on the slide. So approximately how many concerns does the GOC receive each year regarding registrants' fitness to practice? 4 options: 250, 500, 750, or 1,000.
So we've got 27% of you think it's 250. We've got 40% of you think it's 500. 26% of you think it's 750, and 7% of you think we receive over 1,000 concerns a year. Over to you, Keith.
Yeah, so we are expecting to receive about 250 complaints this business year. Has gone down a bit over the course of the last 12 months, which may well be COVID related, of course. In previous years, it has been more in the region of sort of 400, 450, but that's where we are at the moment. And as we do these little tests around the figures, do keep in mind the starting point in terms of the number of individuals and businesses who are on the GOC register. If you remember that starting point, which is just over 30,000. So you can see immediately just even how small the number of referrals are that we receive. So we've looked at the triage process, and we're going to go forward into the investigation process in a sec. But just stepping sideways briefly, there is another process that can be invoked in cases where we identify that the complaint or the concern raises a potentially serious risk to the public or to the public interest, or, and this sometimes sounds bizarre, I know, where it may actually be in the registrant's own interests for an interim order to be imposed. And this is it's pretty rare. I think in 2020 we made something like 11 or 12 applications, and this is where we make a formal application to the Fitness to Practice Committee for an order to be made, which could either be an order for a registrant to be suspended from practice, or for specific conditions to be applied to their practice for a period of time while the matter is being investigated and while the fitness to practice process goes through to a conclusion. So this is it's a draconian measure. So we only do this, and there are very specific rules around this. So if we are saying that this is for the protection of the public, the key word is necessary. We've got to be able to show that this is necessary as a risk prevention measure. These are private hearings. The outcome is only published if an order is made, and you may know this already. If you are an employer, you may do checks on the GOC register to see whether there is currently any sort of restriction against someone's practice if you are proposing to employ them. An order can be made on one of those grounds or potentially all three. Very rare for an order to be made in the public interest on its own. There's a very high bar to meet to be able to say that someone's practice should be restricted just solely in the public interest when a matter hasn't been determined factually. And that's something that always needs to be borne in mind. This is a risk assessment process. It isn't a fact-finding process. Conditions of practice, usually most common in clinical cases where there's a clinical concern, usually would involve things like having a supervisor in place who produces regular reports for the committee relating to the issues that have been complained about. Or in health cases, there would be potentially medical reports being provided on a regular basis. But as I stress this is, say, 11 or 12 applications in the last year, so very, very small numbers. So quick quiz number 3. So we've talked about how many concerns we've received in the past year. So what percentage of concerns received into the GOC each year do you think are progressed to a full investigation? 30%, 40%, 50%, or 60%?
So we've got 62% with 30%, 30% with 40%, 7% with 50%, and 1% with 60%.
Okay, thank you. That's not easy to say, is it? So 62% correct. And I suspect you're kind of getting the idea here that these numbers are actually pretty low. So yes, it's 30% of concerns received in 2020 to 2021 were progressed to a full investigation. Previously, that has been as high as 50%. But as I said, our reform of our triage process, the implementation of acceptance criteria, has brought that percentage down quite significantly, and that is something we are particularly pleased about. So, for those cases that do go onto the formal investigation stage, what does that actually involve? Well, it depends obviously on what the concern is. So for cases where the concern is clinical, then that will generally involve us obtaining records from the relevant optical practices. If the patient's been to hospital, we will obtain hospital records. We may take witness statement from the patient, possibly others if required. Generally these days we are obtaining more expert clinical opinion at the investigation stage. If the case relates to criminal matters, then we will obtain information from the court or from the police. And all of this information is gathered together. It's important to stress that investigations are neutral acts. So the GOC is not seeking to prove that here what has been said by the complainant is true. The GOC, its obligation is to gather information that is relevant to that complaint, and to then put that all together. Case officer will then draft a case report, having obtained all of this information, will draft allegations, and all of that information and that case report are then provided to the registrant, who has, under our rules, 28 days to then provide their response to the complaint. It's not compulsory. We would always encourage people to do so, of course. In most cases, the registrant's response is then seen by the complainant, who has an opportunity to comment on that. And then all of that information, so the investigative material, the registrant's representations, any comments from the complainant are all passed on to our case examiners to make a decision on whether the matter should go any further from there. So our case examiners work in pairs. So each case is considered at this stage by a pair of case examiners. One of them is a registrant. So if the case relates to an optometrist, then it will be an optometrist case examiner. And one of them is a lay case examiner, which will be a lawyer. They work on the papers only. So there's no one in front of them. They've got the papers that I just outlined. And their role is to act as a filtering mechanism. And to do that, they apply this test. It's called the realistic prospect test. It's in 2 parts. It's on the slide. And this is a test that it's not set out in legislation or anything like that. It's evolved through case law over the years. And there are 3 key words in there that I've underlined. So the first part of the test is the factual part. So they have to decide for each part of the allegation whether there is a realistic prospect of those facts being proved if the matter were to be referred to the Fitness to Practice Committee. And the key word is realistic. As the case law says, it must not be a remote or fanciful prospect. For any parts of the allegation where they say there is that realistic prospect of proving the facts, they then go on to consider if those facts were proved for each of those allegations, are they significant enough, with significant being the key word, to indicate that the registrant's fitness to practice could be found to be currently impaired to a degree that justifies action being taken against their registration. So the third key word there is currently, and you'll see this again when we get to the Fitness to Practice Committee stage. Fitness to practice or impairment of fitness to practice is always about today. It's not about the day that the events, the acts or omissions were alleged to have happened. It's about the registrant as of the date that things are being considered by case examiners or by the committee. And this is where remediation comes in. So, you know, as registrants will often in their representations to case examiners talk about the things they've done, the learning they've taken from the complaint, even if they're not admitting all aspects of the complaint. So if they're contesting some of the factual parts of it, they may still have said, well, they may still say, actually, there are things here that I've learned from this. Maybe it's a customer service thing, maybe it's a specific clinical thing, and I've done X, Y, and Z to improve my practice. And all of those things will be taken into account by case examiners when they're applying the realistic prospect test. So remediation is a very key part of the process. And we're starting as well, you know, at the triage stage, where we mentioned that we will obtain information from registrants sometimes at that very early stage. And that can be relevant then as well, because sometimes those complaints come to us into our triage system, and you know, and they may have been knocking around for some time with the practice, and the registrant at that stage may be able to say to us, well, actually, you know, I accept there was something in that complaint, but I've done X, Y, and Z to improve things, and we may take some reassurance from that. So remediation is a very key word in this process. Begins as early as triage, becomes very important at case examiner stage, and we'll come back to it again as I go through the slides. Case examiner decisions, if they do decide to refer to the Fitness to Practice Committee, there is a right of review via our Rule 16. So those decisions can be looked at again by case examiners if they decide to refer. Quick quiz number 4. So for this one, what percentage of concerns considered by our case examiners do you think are closed by them at that stage? Is it 25%, 40%, 65%, or 80%?
So we've got 11% are saying 25%, 29% are saying 40%, 41% are saying 65%, and 19% are saying 80%.
Okay, so I think it was the 41% that said 65%. Well done to you. Obviously appreciate these difficult questions to answer. But yes, in 2020, in the last year, basically 65% of cases closed by our case examiners at that stage. That has been as high as 83% in the past, which sounds a good thing on the face of it, but actually it was concerning because what it told us was that too many low-level complaints were coming into the system. So as perverse as it sounds, we actually want our closure, the closure rate should start to come down over a period of time, because it should only be the more serious concerns that are in the system. So just quick look at the potential options open to case examiners at their stage. They can close cases, and got some percentages for the last year in next to them. They can close cases with no further action. They can do that, but also issue informal advice. They can issue a warning that's non-public, or they can refer the case to the Fitness to Practice Committee. There's also two other options around assessments for health or performance, but actually they are fairly rare these days. So if a case is referred on to the Fitness to Practice Committee, I think it's fair to say the process becomes slightly more adversarial at this stage. It kind of flips, because having been a neutral act at investigation stage, the GOC is now required to prepare a case for hearing. We still have to operate, obviously, on the principles of fairness and making sure that cases only go forward if they need to. But we actually have to prepare a case and instruct a lawyer to present the case at the hearing. So we will add sort of finishing touches to the investigation process, serve our final bundle of documents on the registrant, so that may be material we're relying on, and any material we've got that we're not relying on, lists of witnesses, how long we think it's going to take. Under our rules, our registrants then have 4 months to prepare their own case for the Fitness to Practice Committee hearing but 28 days in, there are some requirements under the rules for registrants to let us know various bits of information about how long they think the hearing will take, whether things are admitted or defended, etc., etc. More recently, we've introduced case management meetings as part of our scheduling process. So, and this has been a very useful innovation, and so the registrant and their representatives and the GOC and its representatives meeting at least once, sometimes twice before a hearing, just to do bits of tidying up and housekeeping to make sure that hearings run smoothly. So for quick quiz number 5.
So the question is, how many registrants have been erased from the GOC register due to a finding of impaired fitness to practice over the last year? And your options are up on the screen now: 0 to 5, 6 to 10, 11 to 15, and 16 to 20. 52% of you think it's between 0 and 5, 38% of you between 6 and 10, 8% of you between 11 and 15, and 2% of you between 16 and 20. Are you back, Keith?
I am, thank you. So 38% who said between 6 and 10. Well done. That was the so the figure for the last year, as we come towards the end of March, is 6. So yeah, very low numbers. And again, referring back to the very first question around how many registrants were on the register, and then so you're coming down from 30-odd thousand registrants through 250 complaints, and then 35% of those being referred to the Fitness to Practice Committee, and then at the end of that, somewhere between sort of 6 and 10 on average being resulting in erasure from the register. So very low numbers. So Fitness to Practice Committee stage. So the Fitness to Practice Committee hearings are public hearing, unless health related. Health cases are generally held in private. Our committee has 5 members. We don't particularly like this. We're an outlier on this. Most other regulators have 3. but that's what our legislation says. So there is a lay majority, so 3 lay members, one of which is the chair, and 2 registrant members. Again, the registrant members will reflect the registrant who is subject to the proceedings. So if it's an optometrist who has been referred to the committee, then the 2 registrant members will be optometrists as well. There's an independent legal advisor. Generally, so the GOC will have a case presenter, a lawyer. Most registrants are represented legally at this stage, and witnesses will be called on both sides. The burden of proof is on the GOC, so it's up to the GOC to prove that the allegations that are in front of the committee are true. And this is to what's known as the civil standard of proof, and some of you may be familiar with this. So you may be familiar with the criminal standard of proof, which is beyond reasonable doubt. So a very, very high standard of proof in criminal cases. In civil cases, it's on the balance of probabilities. So sort of 51-49 if you want it in sort of more simplistic terms. Let's say witnesses will be called in a standard clinical case. The GOC is likely to call as a witness the patient and probably an expert witness as well. Registrant is likely to give evidence and will probably have an expert witness of their own as well. And the panel has to make findings in 4 stages. And they firstly have to decide which of the allegations they find the facts proved in respect of. And for those, they will pause at each of these 4 stages, and you get a written decision at each stage. So they'll issue a written decision in respect of the facts. So which of the allegations do they find proved? Moving on to the next stage, and there are submissions from both sides at each of these stages as well. So if, for example, it's a clinical misconduct case and they find all or some of the facts proved, they then have to decide whether those facts amount to misconduct. And as I mentioned at the very beginning, serious professional misconduct as set out by the case law. If they decide that it does, then they'll move on to impairment stage. And this is where remediation comes back in. So the committee at this stage will hear from the registrant. Generally, registrants will give evidence at this stage and may want to call witnesses as well. So this again is about what learning has been taken from the case. Have they done anything in particular? It's about reflection and insight and all of those things that the committee will want to hear from the registrant. Because remember, as I said earlier, the committee is assessing that registrant's fitness to practice as of that day, not as of whenever these matters arose. If the committee decides that the registrant's fitness to practice is currently impaired as of that day, they will then go on to sanction stage. If a sanction is imposed, there is a secondary question around whether or not that sanction should be immediate or wait for the outcome of any potential appeal. I won't dwell on those, just looking at the time. I won't dwell here either. This is the leading case law for impairment stage, which I think is, I put this in because it's of particular interest, I think. So this is what the committee is looking at when they decide whether a registrant's fitness to practice is impaired as of today's date. So it talks about whether conduct or misconduct is potentially capable of being remedied. Has it been remedied, and what's the risk of repetition? So that's one you can look at outside of this session if you wish to. But in terms of the sanctions available to the committee, if they get to that stage, and not all cases get to that stage, they can actually decide no sanction, or two other outcomes which we talked about at interim order stage. Conditions of practice can be imposed as a substantive sanction for a period of up to 3 years, suspension up to 12 months. Financial penalty, certainly in my time at the GOC, I've never known that to be applied to an individual. Generally, I think perceived to be reserved potentially for business registrants. And the ultimate sanction, of course, is erasure. And we've already looked at the very low numbers around that. The committee must impose the sanction that is the least severe, that serves to protect the public or to mark the public interest, or to do both, if that is what is required. So they're not, it's, just flicking back again to the very beginning, it's not a punitive process. It's about, always comes back to protection of the public, and potentially to protecting the public interest. So actually, I've done okay, I think, time-wise. So we're now into some of our case studies. So the first one, and I should preface these by saying, obviously, we're only giving you a certain amount of information, so we accept it's a little bit unfair, but hopefully they'll be of interest to you and just give you a little bit of an opportunity to sort of put yourself in GOC shoes. So first one is at triage stage, so that very beginning stage where we're still just weighing up the complaint and deciding whether we should pursue a case. Patient has made an emergency appointment, having experienced floaters and a loss of vision in their left eye. The optometrist was unable to obtain a clear view of the eye and diagnosed cataract. Patient went to hospital where detached retina was identified and patient had corrective surgery. Patient now has much reduced vision and further surgery is required. Clinical advice was obtained. So not a lot of information to go on. We asked you at this stage, what would you do? Would you open an investigation in this case, or would you shut it down at this stage?
We have 3% that would close the complaint, 80% that would request further information, and 16% that would open an investigation.
Yeah, okay, thank you. So this one, I can tell you, was opened. As I said, I haven't given you all the information, so a little bit unfair perhaps, as I said. So we did obtain clinical advice in this case, and the advice was to the effect that there was quite a strong likelihood that the detachment was present at the time of the examination, and that there was no significant lens opacity that would have obscured the registrant's potential view of the fundus. Although a one-off clinical matter and one-off clinical incidents are specifically mentioned in our acceptance criteria as something we will consider very carefully. In this case, because of the potential seriousness around it, we made a decision to open an investigation. Again, I stress, opening an investigation doesn't mean anything of itself. It just means that we go into that more formal process, that neutral act of gathering information for our case examiners to ultimately decide whether something should go any further. Okay, we have a second triage one for you to have a think about. So patient has complained that a sight test lasted less than 5 minutes and that photographs of the eye weren't taken. They then went to another optician a few weeks later where wet macular degeneration was confirmed, and it was also confirmed that the patient had probably had dry AMD for at least 3 years. Patient then had to go on undergo a course of injections and complained that this could have been avoided had the registrant conducted a full eye test at the first opportunity. Again, we got clinical advice. Again, the question is, what would you do here? Would you open the case or close it down?
9% closed the complaint, 40% requested further information, and 51% opened the investigation.
Okay, so this one was actually closed, and it's interesting, and I hope you can see where we're going with these, and that it's very, it's interesting when you first just see some sort of basic information about a complaint that can appear potentially quite serious on the face of it. But in this one, the information we had was submitted for clinical advice, and although the advice said that, yes, potentially this could fall far below the standard of a reasonably competent optometrist, and there were some side issues around legibility in respect of record keeping, on the whole, the clinical advisor was satisfied that the registrant had conducted an adequate sight test, and felt that the registrant would present only a very low risk. And although, and there were also OCT scans taken at the time of the second sight test, where which seemed largely unremarkable and with no obvious signs of wet AMD at that point. So obviously that was supportive of the fact that at the first examination that it was very unlikely that wet AMD was present. So on that basis, on the basis of the clinical opinion we obtained, we felt comfortable in not pursuing that one any further. Record keeping, although that was raised as an issue, as a side issue, our acceptance criteria says that record keeping in a sort of single case scenario is not something that's going to meet the threshold for being taken any further. So that was the second triage case. Moving on, third case we have is at case examiner stage. So we've been through an investigation in this one. So this case is where a patient had noticed something wrong with their vision, so booked a sight test. Registrant has detected dry AMD and advised monitoring through an Amsler grid, and advised patient to return if there's a change in vision, otherwise just a 12-month recall. Patient's then gone to a different practice a few months later and been diagnosed with early wet AMD. Records indicate that an adequate sight test was completed, external internal dilation OCT. Patient also had cataracts, which could have accounted for the reduced visual acuity. Patient history showed parent also had AMD. Clinical risk assessment suggested patient had wet AMD at the time of the initial sight test. Registrant had potentially failed to manage appropriately by not referring. On the flip side, the registrant presented information to our case examiners showing that they had actively tried to improve their knowledge regarding wet AMD by undertaking targeted CET courses and by shadowing an ophthalmologist in wet AMD clinics. So putting yourself into the shoes of our case examiners, what do you think you would do with this case? Would you close the case with no further action, close the case and offer advice, close the case with a warning, or refer the case on to the FTPC?
17% closing the case with no further action. We have 59% closing the case and offering advice. We have 21% closing the case and issuing a warning, and 3% would refer the case to the FTPC.
Yeah, well, the official answer as to what actually happened was A, the case was closed with no further action. But I think if you're in A, B, or C, there you're sort of in the right ballpark. Because the case was closed, the issuing of advice is something that case examiners will sometimes do. It's not a formal marking against the registrant in any way. It's exactly what it says. It's intended as helpful advice to assist that registrant with their practice going forward. In this case, the patient believed they should have been referred by the registrant at the initial sight test, and that the delay had caused their vision to deteriorate. But the records actually showed that the registrant had advised the patient to seek attention should things get worse, and they had the Amsler chart to monitor the changes. Our clinical risk assessment suggested that there were no signs of wet AMD at the time of that sight test. And the main issue arising from our clinical risk assessment was that there was no record of the registrant having advised the patient about the risk of progression from dry to wet AMD. There was also, I'm not going to try and pronounce this, I'll use the abbreviation PED, that could not be explained, and that needed further investigation. But that hadn't happened either, so concern was raised by the clinical advisor about that. But overall, case examiners noted that it was a one-off isolated incident, and they noted as well the actions that the registrant had taken to improve their knowledge regarding wet AMD through those targeted CET courses and by shadowing the ophthalmologist. And on that basis, they were, in applying the realistic prospect test, were comfortable that there was no realistic prospect of that registrant's fitness to practice being found to be impaired. So again, that's a good case because it reinforces what I've been saying around the importance of remediation at all stages of the process, and really kicking in here at case examiner stage. Next one is at fitness to practice committee stage. So this one, our patient has been seen by the registrant 4 times in the preceding 5 years. Believes this site could have been saved if warning signs of his glaucoma had been noticed by the registrant. Field plot tests had show evidence of this defect progressing on all occasions, and the final examination, registrant has referred the patient for cataract surgery with no mention of glaucoma. The registrant has admitted the allegations, but has said that they have sold their practice and intend to retire, and haven't attended the fitness to practice committee hearing. At that hearing, an expert witness has said that the registrant's performance has varied from below to far below the expected standard of a reasonably competent optometrist. And the committee have decided that the admissions amount to serious professional misconduct and that the registrant's fitness to practice is currently impaired. So your decision is on sanction. So you've got 4 options. Do you think there was no sanction, conditions of practice, suspension, or erasure?
5% had no sanction, 18% would have issued conditions of practice, 27% would have suspended, and 50% would have erased.
Yeah, thank you. So perhaps surprisingly, the outcome here was suspension. I can understand why quite a high percentage of you may have gone for erasure, given that the registrant didn't engage with the process and didn't attend the hearing. Actually, the committee, having found misconduct and impairment, decided to give the took into account the fact that the registrant had admitted the allegations, and decided to give the registrant more time to consider if they wanted to undertake remediation activity. So they'd obviously determined that the conduct was capable of being remediated. So they effectively, through suspending for 12 months, they effectively offered the registrant time to undertake that remediation activity and potentially to return to practice if they wanted to. So that was a 12-month suspension with a review. So there would be a review hearing before that suspension expired, at which the registrant would, if they wanted to, come back and talk to the committee about any remediation activity they'd undertaken. In the actual circumstances of the case, the registrant, I believe, if I recall correctly, chose not to do that. There was a 5th one, but I'm going to stop there because Dionne has said we've got some questions. I've got a couple more slides I'll go through very quickly though, and then we'll take those questions. So just very quickly, on fitness to practice committee process, having talked about sanctions, there are rights of review and appeal from fitness to practice committee decisions. So registrants can appeal to the High Court. The Professional Standards Authority can also appeal if they think the committee's decision fails to protect the public. The GOC has no right of appeal. Sanctions are generally reviewed. Suspension and conditional sanctions are usually reviewed prior to expiry, as I've just said. Even erasure isn't necessarily forever. There is a right to apply to restore to the register if you are erased after a period of 2 years has elapsed. I'll skip that one. I was going to talk briefly about some of the things we're doing going forward, but I'd rather take the questions, I think. And just finally on the slides, just to make you aware, there is a whole process going on with the Department of Health and Social Care around reforming regulation. So legislative reform is going on in the background. currently the department's working with the General Medical Council to reform their legislation. They will be launching a public consultation, the department, imminently. So do look out for that, as it gives you an idea of how fitness to practice processes will look in the future. So I'll stop there. That takes us on to questions.
Thanks, Keith. I'll give you a minute to grab yourself a glass of water. There's a couple that I can run through quickly first. The first question that I'll answer is, there was a question about whether or not we'd received more concerns during the coronavirus pandemic. The answer to that is no. We didn't drop off as far as we thought we might, but there was definitely a reduction in concerns that we received. And that was it varied across all of the healthcare regulators. Some significantly increased, some dropped to none. We probably reduced by about 20 to 30% in terms of incoming concerns during the pandemic. The type of concerns were a little bit different, and who we got them from was different, but the number just slightly smaller. There's another question, which is, what is the biggest cause of complaints against optoms? I just had a very quick look back on that. The top 3 concerns that we get every year are primarily around personal conduct, so the personal behaviour of our registrants. Secondly, it's declaring a conviction or caution. And thirdly, it's around other clinical conduct, and that can include anything to do with clinical practice. And I just had a look at the preceding 3 years, and they generally vary. They're usually between 10 and 15% of all of our complaints are in each of those areas, but the order of them slightly changes. One for you, Keith, please, if you're ready, is, does the complaint, oh no, that one was for me, I can take that one in a second. I think this one's quite a good one. I wouldn't mind you tackling, Keith. It's a full GOC hearing seems to take much longer than an average GMC, GDC and GPC hearing. This can be very distressing for the mental health of the registrant and their loved ones. Is there any reason for the longer process compared to other healthcare? So I know we're doing a lot of work around that. Do you want to touch on that one?
Yeah. So I think timescales, it's a very fair question. Timescales of our cases are our biggest challenge at the moment. The reform of the triage process was the first part of helping us get to a better place with timescales, because we were overwhelmed with cases going back a couple of years. So having reduced the number of cases, we're now starting to get the timescales down. Statutory time that's built into processes does vary from regulator to regulator as well. We mentioned about registrants having 4 months in our process to prepare their case for a hearing. I don't know off the top of my head what the GMC timescale is. It might be the same, it might be shorter. So there are some differences, but yes, timescales is a key issue for us, and something we're working very hard to speed up. We totally understand that this process is very stressful for everyone who goes through it.
Yeah, absolutely. Thanks, Keith. And we are looking for alternative ways that we can support the sort of emotional challenge that registrants and all parties to the case as well. Another one for you, Keith, please. If you resign registration, does the FTP investigation cease?
Generally, no. But this is something we're looking at the moment. So our current policy says that we have to retain someone on the register so that we can complete the fitness to practice process. But there's lots of different views on this, and we have started a piece of work to look at whether it is possible within our legislative framework for us to develop a process that would, in some cases, allow registrants, if they wish to come off the register and for the process to end at that stage. There is a wider public interest in more serious cases having a public hearing, and that has to be part of that consideration. But other regulators have that process. It's called voluntary removal. It's something we're at very early stages of looking at this at the moment. Our legal framework is a little bit restrictive, but we are exploring this to see if there's something we can do.
Thank you, Keith. I'm just flipping through. There might be some we won't get to here. I will just grab another one, which was, does the complainant often appeal if the case is closed before going the full course? I can probably cover that one off. The appeals will come to me. I'm quite removed from the decision-making function in triage. So if there is an appeal either from the complainant about our decision to close the investigation, or alternatively from the registrant about our decision to open the investigation, they have the right to appeal, as Keith's covered off. I've had 11 appeals so far. I think it was 8 of them from the complainant and 3 of them from the registrant. I overturned one of the decisions to open a complaint against the registrant, and I've upheld generally all of the decisions to close the complaints for the complainant. So not often, occasionally, and they'll just be considered afresh in whether or not we've applied the acceptance criteria correctly. There was one question which I'm going to ask Roma to answer if she's okay, and that was about a GILIC competent child. Roma, can you see that question in there?
Yes, I can. I'd say obviously it's better to have a parent there, but if the child's GILIC competent and you're confident and feel comfortable that they can provide informed consent, and the parent's obviously happy for you to take the child in without them, then I think it would be okay. Obviously, the GOS form requires a parent signature, so you'd have to factor in these kind of considerations. But I have worked with optons in the past who will leave a door open, check the parent's happy, check the child's comfortable. If they do have any questions, check they're happy to relay the information to the parents at the end. But you'd have to assess it on a case-by-case basis.
Thank you. I'm just very conscious it's 7:30. There's probably 2 more questions we can cover off here if we're happy to go on, or I can stop now. I think they're relatively quick. Keith, first one is, where does the OCCS sit within this structure?
Yeah, that's grateful for that question. So part of our consideration at triage stage is we get quite a number of complaints where actually someone's complaining about what we call consumer matters. So maybe they're unhappy because you bought new spectacles and they've fallen apart or something after a couple of weeks, or that's that sort of complaint. They're after a refund or replacement optical equipment. So those matters are much more suitable for the OCCS because they can they're a mediation service, and they can mediate between the patient and the practice and potentially provide the patient with a more meaningful outcome. And a lot of those cases would not reach our threshold for investigation anyway. And if someone's just after a replacement pair of specs, a fitness to practice process is not necessarily going to get them there. So yeah, it's a service that's provided by the GOC. It's provided independently by a firm of solicitors called Knockhold's been running that service since 2014 very effectively. So yeah, very worth being aware of, and registrants can refer matters to them as well, not just patients.
Thank you, Keith. Noted they provide an excellent service, and if they do engage with you, I'd heavily recommend that you do engage back. Final question, if I can, on this one, because this does come up quite a lot. It's not the last question on the list, but it is one that I know we get a lot of. Does one need to report any medical condition that an optom may have?
This is a thorny one. Our advice, obviously, there's declarations guidance on our website. We, I think, generally as an organisation accept that it needs some work to try and make it a bit more helpful to everyone. So our overarching advice is always, if unsure, I mean, always you can speak to your professional body, of course, but if unsure, do declare. We really don't like putting health cases into the fitness to practice process if it can be avoided. If someone's not well, obviously that's not their fault. It's not a process that's going to necessarily make anyone feel any better. So obviously there are public protection considerations, but so my advice is always, if in doubt, declare, and either the registration team will either say that's fine, you don't need to declare that again, or even if they do pass it on to the fitness to practice team, that doesn't mean that it's necessarily going anywhere. So it's something, Dionne, we sit around and discuss those at great length, trying to find ways not to put them into the system.
Yeah, and I think if you one of the overarching messages from Keith in this is it's really about the fitness to practice. So The guidance does state quite clearly that we ask you to make a declaration only if it may directly affect your fitness to practice. Sometimes health conditions, you may not be aware on whether it affects your fitness to practice. And what we're really looking for when we assess it is whether or not you have the insight and the awareness or understanding into your own health to enable you to manage it so that it doesn't affect your fitness to practice. Ultimately, as Keith says, we don't want to take people necessarily through fitness to practice processes if we can show and demonstrate in those early stages that you remain fit to practice because of your self-awareness on that one. So it's a really difficult one for us. I do encourage you to read the declarations guidance that's on the website. There's one specifically for students, and there's one for, I think there's one for businesses. I know there's one for students and definitely one for fully qualified registrants. I think that probably means we have to come to an end, unfortunately. I was hoping we might have time to just squeeze in the final case study because I think it's quite a fun one, but we have run over. So I will, I think, draw this to a close if that's okay. Thank you all so much for coming. We've had about 280, up to 280 attendees today, which is incredible. So thank you very much on behalf of the three of us and the GOC for giving up an hour of your time this evening. I hope there's been some useful takeaways. If there is any more that you want to know, we are currently publishing a quarterly FTP focused bulletin designed for our registrants to share more of the learning from fitness to practice. You can contact us with thoughts about what you might find interesting. We are trying to make it very much registrant led. So if you want to drop us a line, please do so at focus@optical.org. Thanks so much. We know it's been a really difficult year for our registrants. We know it's not been easy for you at all. We're hoping that there's light coming through the end of the tunnel, but you've done an amazing job in keeping our sector running through very difficult circumstances. Hope that you and yours have all stayed safe and well, and well, here's to brighter days ahead. But thank you very much for your time this evening. Appreciate it.
Yep, thank you.
Thank you.